Lesson 48, the 14th Amendment and Equal Protection. Let's review the Equal Protection Clause of Section 1 of the 14th Amendment. No state shall deny to any person within its jurisdiction the equal protection of the laws. The first question we want to ask, do minors have the same equal protection rights as adults? The case in regards to Galt, 1967, in regards. Gerald Galt was a 15-year-old. He was taken into custody for allegedly making lewd phone calls. He had previously been placed on probation. The police did not leave notice with Galt's parents, who were at work, that Galt was arrested. He remained in custody for several days until being released to a detention home without explanation. Galt's mother received a note from the superintendent of the detention home informing her that, quote, Judge McGee has set Monday, June 15, 1964 at 11 a.m. as the date and time for further hearings on Galt's delinquency. This was the family's only notification of the hearing. Galt's accuser, a neighbor, was not present at the hearing as well. Judge McGee said she did not have to be present. No witnesses were sworn in, and the court made no transcripts of the hearing. After a couple of hearings before Judge McGee, Galt was committed to the State Industrial School until he reached the age of 21. The case was eventually taken up by the Supreme Court. The court ruled that the proceedings of the juvenile court failed to comply with the Constitution. The court held that the proceedings for juveniles had to comply with the requirements of the 14th Amendment. The Due Process and Equal Protection Clauses refers to no person shall be denied those rights, not adults, no person. These requirements included adequate notice of charges, notification of both the parents and the child, the child's or juvenile's right to counsel, the opportunity to confront and cross-examine witnesses, adequate safeguards against self-incrimination. These are your Fifth and Sixth Amendment rights. So, before we move on to Roe versus Wade, the question we want to address now is the right to privacy. But in conclusion, certainly, yes, minors have the same due process and equal protection rights as adults. Now, what about privacy? Are you in the mood to exercise our constitutional rights? Landmark case Griswold versus Connecticut, 1965. Estelle Griswold was the executive director of Planned Parenthood League of Connecticut. She and the medical director for the league gave information, medical advice, instruction, and contraceptives to married couples in order to prevent pregnancy. This actually was a violation of Connecticut law. Griswold and her colleague were convicted under the Connecticut law, fined $100, that criminalized providing birth control to married persons for purposes of preventing conception. It's Connecticut, early 1960s. The Connecticut Supreme Court upheld the conviction under Connecticut law, and the case was eventually taken up by the Supreme Court. The issue in the case boiled down to this. Is there a constitutional right to privacy, although the Constitution does not explicitly state that right? William O. Douglas wrote the majority opinion for the Supreme Court. Though the Constitution does not explicitly protect a general right to privacy, the various guarantees within the Bill of Rights create zones that establish a right to privacy. One justice wrote a concurring opinion in which he used the Ninth Amendment to defend the Supreme Court's ruling. Remember, the Ninth Amendment says that the listing of these rights in the Constitution should not be interpreted that there are other rights not listed. In other words, not every right that we have as citizens is listed in the Bill of Rights. That's basically the gist of the Ninth Amendment. Two other justices wrote concurring opinions in which they argued that privacy is protected by the Due Process Clause of the 14th Amendment. So taken together, the First, Third, Fourth, Ninth, and 14th Amendments create a new constitutional right, a right to privacy in marital relations. This would be a loose construction of the Constitution as opposed to strict. Two justices filed dissents. One argued that the right to privacy is to be found nowhere in the Constitution. See, that would be a strict construction. Furthermore, he criticized the interpretations of the Ninth and 14th Amendments to which his fellow justices adhered. The other dissenting justice called the Connecticut statute an uncommonly silly law, but argued it was nevertheless constitutional. These two justices would have a strict construction as opposed to a loose construction. Now the biggie, Roe versus Wade. The abortion case, 1973. You've seen a lot of these cartoons. The secretary says, Stu, we need an abortion cartoon that's both funny and memorable, but doesn't offend anyone. No problem. I'll do it right after I create peace in the Middle East. Obviously, this is a controversial issue. Strong feelings on both sides. What's the background of the case? 1969, Norma McCorvey discovered she was pregnant with a third child. She returned to Dallas, Texas, where friends advised her to assert falsely that she had been raped in order to obtain a legal abortion. Because under Texas law, they allowed abortion in cases of rape or incest. But those were the only two exceptions under Texas law. The scheme failed because there was no police report documenting the alleged rape. She attempted to obtain an illegal abortion, but found the unauthorized site had been closed down by the police. Eventually, she was referred to attorneys Linda Coffey and Sarah Weddington. McCorvey would actually give birth before the case was decided. It still became a very famous case on abortion, a woman's right to choose. In 1970, Coffey and Weddington filed suit in the U.S. District Court in Texas. Remember, that is a United States trial court. The U.S. District Court is a trial court at the federal level. The alias she used was Jane. The defendant in the case was Dallas County District Attorney Henry Wade, representing the state of Texas. McCorvey was no longer claiming her pregnancy was the result of rape, and later acknowledged that she had lied about having been raped. The U.S. District Court ruled in McCorvey's favor on the merits of her case, but declined to grant an injunction against the enforcement of the laws barring abortion. An injunction is a stop order. Stop. Cease. Until the court can hear a case. The United States District Court's decision was based on the Ninth Amendment, referencing the Griswold versus Connecticut case just discussed, under the right to privacy. Roe versus Wade reached the Supreme Court in 1970 on appeal. Lots of delays. The question is, does the Constitution embrace a woman's right to terminate her pregnancy by abortion? That's the question. There was a 7-2 ruling in favor of Roe, 1973 ruling. The court held that yes, a woman's right to an abortion did fall within her right to privacy, as established in the Griswold case. Harry Blackmun wrote the controversial majority opinion. The right to an abortion must be balanced against the state's, in other words, government's, two legitimate interests in regulating abortions. One, protecting prenatal life. Two, protecting the health of the woman, or woman's health of the mother. Arguing that these state interests became stronger over the course of the pregnancy, the court resolved this balancing test by tying state regulation to abortion to the trimester of pregnancy. Now, what do we mean by all this? The first trimester, the first 3 months of pregnancy, a woman has total autonomy or control over her pregnancy. However, as she enters the second and third trimesters, this is when the government has an interest in looking out for the life of the unborn. The court later rejected Roe's trimester framework and adopted the point of viability instead, when the unborn becomes viable, meaning to exist outside the womb of the mother. Viability, potentially able to live outside the mother's womb, albeit with artificial aid. Usually that's 24 weeks or so. After the point of viability, the government has a compelling interest to protect the life of the unborn, and a woman cannot secure an abortion. After the point of viability, only can she secure an abortion to protect her health. There are three main arguments against the Roe decision and why the Roe case is controversial and has many opponents. The first argument, it lacks a valid constitutional foundation. The Constitution is silent on the issue. Strict constructionists would support this argument. The second argument is that the proper solutions to this very sensitive question should be left to state legislatures and the legislative process, rather than an all-encompassing ruling by the Supreme Court. Critics claim, and I might add rightly, that Roe versus Wade is another case of judicial activism, that the judges were actually writing abortion law. And law should be left to legislative bodies, not to the courts. The opposite of judicial activism, of course, is judicial restraint. We've talked about this, where the judge should only interpret the law rather than write new law. The third argument against the Roe decision was when life began. Many believe life begins at conception, therefore abortion is murder of an innocent life. Those who supported Roe versus Wade, it's a woman's right to choose what to do with her own body. This is about personal freedom from government intervention. This is about individual privacy. And the 14th Amendment refers to any person. And a fertilized egg is not a person and cannot enjoy 14th Amendment protections or equal protection. Because the unborn is not a person. The debate continues. Stop abortion now. Keep abortion legal. SaveRoe.com. Overturn Roe versus Wade. Yes, we can. Keep abortion legal. A person's a person no matter how small. Women deserve better than abortion. Keep abortion safe and legal. Face it, abortion kills a person. Why Roe versus Wade is called a landmark decision. When does life begin? At the moment of conception. At birth. When you get your driver's license. Well, that's probably not a funny joke. It's a serious issue. Roe versus Wade. The right to have an abortion, to terminate a pregnancy. Within the first trimester or 22, 24 weeks of pregnancy, a woman has that right. And after that point, the government steps in to say, no, we're protecting the life of the unborn.